one moment. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justice of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel this morning for the 4 cases on our hearing list are Justice Ariane Butow and Justice Robert Brennan. The first of our 4 cases scheduled for hearing today is case number 2022 P342. The case involves the termination of parental rights, and the case is impounded. I've reminded counsel to refrain from referencing the impounded material. We are hearing this case on Zoom with public access through our YouTube channel. Following the hearing in this case, we will take a brief recess while the justices move to the Hale courtroom, where we will hear the remaining 3 cases in person. With that, counsel for the father, you may begin.
Thank you very much. Good morning. May it please the court, Lynn Eisenman on behalf of the father. Your honors, as you know, this is a competing plans case with the department presenting the foster mother as the adoptive resource for the child and father presenting his sister as the adoptive resource for his daughter. Father's asking that the court vacate the order approving the child's foster mother as her adoptive resource so that his sister can adopt the child. Here we have a child who's 3 years old. She seems to adjust well to changes in her life. She does not have any, as of the time of trial, significant medical, educational, or other therapeutic needs. Really, the only service that she had been receiving up until the time of trial was engagement in early intervention, and that was ending just because she was aging out of the service.
Can I just ask you, just not
Sure.
to point on it, but mine is the child not 4.5?
She is, and when I say 3, I am referring to the time of trial.
But
just
now she's
because
4.5, and am I correct that this is the only mother, the only family this child has ever known?
Correct. So she was born in June of 2019, so she's just shy of 4.5. But she has been placed with her foster mother essentially since the time she was discharged from the hospital after birth. That's correct.
Has she ever seen or spoken to the aunt or the sister?
She had not. And that was,
I take it.
I frankly don't have an update since trial, but as of the time of trial, when the judge was considering the evidence, she had not. And that was one of the issues certainly that the judge had. I will say that the aunt lived in Georgia, as we know. She was never told by the department, by Massachusetts DCF, that she was entitled to visits with this child. She did not have counsel of her own to represent and advise her. The department did, during its testimony, that the social worker testified that they were essentially testing her to see her motivation and whether she would ask for visits or not. And then when it came up during trial that she was entitled to a visit and that the department would consider it, she then asked for a visit, was ultimately denied by the department because they were in trial and in the middle of a trial, but never informed that she could not have a visit with the child.
What is the standard of review that we are to apply to the judge's decision?
On the ultimate determination of the approval of the plan, it's an abuse of discretion.
Right. And just to inventory some of the factors that from reading the judge's memorandum of decision that appear to have weighed in that judge's application of discretion, the judge seemed to have some concern that the mother on a previous occasion had facilitated the return of a different child to mother who then absconded with the child, triggering member.
Correct. Right. The aunt's granddaughter. Right.
There were some other factors that also seem to weigh in the judge's decision, but taking that one alone, what is your best argument in those circumstances that it was an abuse of discretion, that it was it's not within the range of reasonable alternatives for the judge to conclude that the placement with the foster mother was a better situation for the child?
Sure. So, I mean, it's in spite of that finding and in spite of that fact, the judge still ultimately concluded that the foster, or that the aunt would be a physically safe place for this child. And
Yes, as long as the child was with that aunt, but the judge also seemed to take note of a statement by the father of his expectation that he would be able to recover custody of the child within a few years.
correct. And I think he certainly wanted to be involved in his daughter's life.
I think the father seems to say more than that, and the mother's history of returning a different child to a mother who was not suitable would corroborate the reasonableness of the father's expectation.
And I think that's that's an issue that comes up with these kinship placements relatively frequently, is that we have family members who are serving as placement resources, and there's a relationship there between the the parent and the kinship placement.
Well, it's one thing, but the question really is one of respect for the court established boundaries, right?
Correct. And I will say, the aunt testified that she will get that information and she will respect those boundaries, and she's going to, for lack of a better description, have eyes on father and see how he's doing and monitor it from her perspective. That I will say that same question was not asked of the foster mother, and I understand it's a different relationship, but there was going to be an open adoption agreement where the father would have visits with his daughter should the foster mother end up adopting her. And certainly she would be free to increase the minimum number of required visits under the open adoption agreement. So,
Were there indicia that the foster mother would potentially simply release the child into the father's full-time care?
I don't know, and I'm not saying that was brought up, or that was an issue, or that was necessarily even a concern. But my point being that the judge asked the aunt about her intentions, but there was no,
in the face of prior conduct that gave rise to a
right. And I guess to circle back, my best argument is that in spite of that the judge still made, concluded that this was going to be a safe place, even going forward. And that, quite frankly, both women were going to be suitable placements. What ended up happening is that the status quo gets maintained, and that, the child, the judge orders the child to remain with the foster mother because she's doing okay there. I think there's no dispute about that. She was there for years.
And just, without impugning the integrity or suitability of the aunt, it hardly strikes one as unreasonable to allow the child to remain in the placement where she has been for her entire life when things are going well there. Right?
Yes.
Well, because
but...
I'm sorry, you don't need to answer that. You have a job to do, and I'm just thinking out loud here. So I'm putting that out there. So without a response, but you understand where I'm coming from.
I certainly do, and I am in no way undermining the job that the foster mother did, and I think that was clear even from father's testimony during trial. He appreciated what she did for his daughter. The argument is we have a family member who was deemed suitable by the court. You know, I also don't want to minimize any impact on the child, but she was 3 at the time of trial, you know, almost 4.5 now. She had adapted well to changes in her life. And, you know, we saw that really throughout the course, you know, and these are the measurements that we have, right? She started visits with father.
Excuse me 1 sec, counsel.
Sure.
What changes are you referring to in her life? No, I mean, certainly not, she was from day 0 with the foster mother.
Right. Not movement, but, you know, the things that we have that are measurable, like, you know, things such as she changed her daycare room and seemed to do fine with that. Her foster brother and sister moved in and out of the house of her foster mother's house. She did fine with that. A foster child moved into the house while she was living with foster mom. She did fine with that. I mean, those are the things that we can measure and that we have evidence of. You know, the aunt did testify. She, you know, had researched therapeutic providers for this child to help her adjust. She was going to take off several weeks from work to help this child adjust should she move down to Georgia. You know, it's not like we had a 7, 8, 9-year-old that would be in a very different position. And again, I'm in no way minimizing that there was not going to be impact on this child if she were to be moved. I think everybody realized that that was a potential, but she had demonstrated an ability to adapt, and there was a plan in place to try to help her adapt if she were going to move.
Can I ask you a different question? Is it your position that a judge is required to explicitly state the applicable standard in her decision?
The standard on preferential weight to either plan, or?
Well, I think your argument was, that's part of your argument, that she didn't on that issue state explicitly the applicable standard.
It was right. I'm sorry, that it was that she didn't state the standard about what weight, if any preferential weight, she gave to the department's plan. She clearly stated she can't give a parent's plan any preferential weight, but we don't know about the department's plan, which is what ended up obviously being approved. And because the status quo gets maintained, if she approves the department's plan, did she give any preferential weight to that? And that's what I'm arguing. We don't know from her findings.
Thank you.
I will say that, you know, I think that the judge had a different amount of information between the aunt and the foster mother in front of her, other than, you know, the child obviously living with the foster mother during her placement in the department's custody. But we have a 160-page home study on the aunt with all of the information and the extensive interviews that were done. Pictures of her residence. We don't have that same information on the foster mother. And, you know, we have the department social worker testifying about, you know, the facts of that placement, and the foster mother and her daughter testifying, but we don't have the actual home study that's performed. So, you know, the judge, quite frankly, did have more information about the aunt than the foster mother in front of her at the time. And so again, you know, father is just requesting that his sister be approved as the adoptive resource for his daughter, and that the order approving foster mother be vacated. So if the panel has no further questions, I would rest on my brief.
Seeing none, thank you for your argument.
Thank you.
Mr. Bayless, you will be arguing first for the departments. Is that correct?
Yes, Your Honor. May it please the court, Jeremy Bayless for the Department of Children and Families. The decision between competing permanency plans is a textbook abuse of discretion decision by the court, not to be disturbed unless the court made a decision that is outside the bounds of reasonable alternatives. And this is a case where the two proposed adoptive placements, putting aside the concerns about the aunt's allowance of her family members to access children when perhaps she shouldn't have, they look largely similar on paper. They make roughly the same amount of money, adjusting for cost of living. They both have homes that the child could fit in, and the court found ultimately that both would be generally a fine placement for the child. However, the court is obligated to make a decision. Neither one of those plans is entitled to any deference. The parents' plan, which it would generally be a family member, is not entitled to extra deference under Hugo, nor is the department's. And so the court then was faced with the decision of trying to decide between two very similar qualified plans. And it was not air for the court to both consider the aunt's behavior in the past with other family members and to consider the fact that, as Justice Brennan has noted, this is the only parent that this child has had since birth. It wasn't just since the discharge from the hospital. The pre-adoptive foster mother actually was visiting her regularly while she was in the NICU. Certainly it might be different if this had been 10 years versus 3, but that's still a significant relationship in the child's life. And so to the extent that the father's arguing that the court should not have considered that bond, that is simply untrue. It is a factor that plays into it. It would be cruel to find that children's bond with the caretakers that they've been living with is something that the court must disregard. There may certainly be facts, and there have been in other cases, where a bond with a pre-adoptive parent is insufficient to make that placement in the child's best interest. There may be specific needs. There may be some unique circumstances of the child. None of those things are present here. This was a case where the court decided between two plans. There are no flaws in the decision, and if the panel has no questions, I'm happy to rest on my brief.
Thank you.
Thank you.
For the child?
Wait for Michael. There we go. Good morning. May it please the court. I'm Alan Campbell, and it's my privilege to represent the subject child in this matter. This is a relatively, straightforward case. Competing plans. Did the judge abuse its discretion in choosing to keep the child in the only home it's ever known? The child argues that it did not. DCF had custody of the child from when she was 4 days old. Almost immediately after that, as my brother mentioned, the foster mother began visiting the child in the NICU while she was going through withdrawal. A few days later, the child was placed with the foster mother, and she's remained there for the past 4.5 years. This is, quite literally the only family she's ever known. She thinks of her foster mother as her mother. She thinks of the foster siblings as her family. She isn't just doing okay there, she's thriving. She's a perfectly normal child having a normal life. And there was no abuse of discretion in allowing the child to remain in this home. Just a couple quick points, because I believe DCF actually said just about everything I was going to. The judge did not expressly state the standard in the findings. However, during trial, the judge, it's a bit of a long quote, I've left a little bit out, but judge says, but again, I remind everyone that DCF's opinion at this stage is not relevant. The court will equally assess both plans. Neither plan gets priority in the court's mind. It's clear from the record that the judge knew what the standard was and applied it properly. She conducted an even-handed evaluation of both plans, found that each plan could meet the child's needs, but then when reaching the ultimate question of what was in the child's best interest, the judge found that remaining in the current placement was in the child's best interest. And the judge was also quite explicit that this wasn't a case of, I'm just maintaining the status quo. The judge looked at what was best for the child and found that remaining in the home where she had lived for 3 years at the time of trial, now 4.5 years, where the child was thriving, was in her best interest. And that certainly is within the realm of reasonable alternatives, such that this court cannot say that it was an abuse of discretion to do so. And unless there are any further questions, I will rest on my brief.
Seeing none, thank you all for your argument. That will conclude the argument in this matter. The case is submitted, and we will resume our session in. Thank you.
Thank you.
Thank you, Your Honor.